Hello, everybody, and welcome back. Our topic today is class action lawsuits, and our guest is attorney Val Exnicios. Now, you may not recognize his name, but you're probably familiar with the cases that he's handled. He's represented Louisiana residents, fishermen, and businesses in multiple lawsuits following Hurricane Katrina and has extensive experience taking on the oil and gas industry.
Not only that, my good friend Val has also chaired and is the chair of the Louisiana State Bar Association section on class actions. Val is regarded as one of the best in this area, and we're glad to have him in the studio with us. But before we get to class actions, Val, I want you to tell us what your take is on this news item about the red mass and the fact that so many African-American judges opted not to attend that mass.
There was an alternate mass yesterday put on by the Louisiana Judicial Council of the National Bar Association, led by its president, Judge Ed Lombard, of the Louisiana Fourth Circuit Court of Appeals. And Judge Lombard and the Louisiana Judicial Council decided to celebrate, convocate, consecrate the rule of law as embodied in the Chisholm and Clark decisions, which established the ability of African Americans to sit on our benches, in particular at the Louisiana Supreme Court, but also created sub-districts wherein African Americans could elect fellow African Americans to the Louisiana judiciary.
Now, the Chisholm case, that's the one that, Shauna, you and I, we've been talking about this, that has been in the news on the front pages of our newspapers, that Justice Burnett Johnson, your friend, mine, who is who's fighting to be recognized as the next Chief Justice on the Supreme Court, correct?
Absolutely. Chisholm was the consent decree that resulted in the 8th seat on the Louisiana Supreme Court. That seat was first held by Justice Revius Ortigue, and then subsequently Justice Johnson was elected to that seat. That seat, by definition and by statute, has all of the privileges, all of the emoluments of office as any other justice on the Louisiana Supreme Court.
And we want to be very clear about this. A federal judge, a federal court, has ruled in her favor. However, it is now before the Fifth Circuit Court of Appeals because the state is appealing that. And the court did uphold that, in fact, she should be named the next Chief Justice of the Supreme Court.
Absolutely. Federal Judge Susie Morgan heard arguments both from the state of Louisiana, or I should say Governor Bobby Jindal's lawyers, and lawyers representing Justice Johnson, and decided in Justice Johnson's favor that, in fact, the Chisholm decision stands for what it stands, and she's entitled to be the next Chief Justice of the Louisiana Supreme Court.
But it's an ongoing controversy, and some people say that what happened here yesterday really sort of put the spotlight on that. Just got a quick take from both of you. Within the legal community here and statewide, what is this doing to the legal community?
Well, unfortunately, I think it is shedding some negative light, obviously, on the justices who are embroiled in this controversy. In particular, I believe, if I can speak for the African American community, their position is there really shouldn't be any debate. There should be no issue. Justice Johnson is the most senior judge sitting on the bench, and as such, she's entitled to be Chief Justice. Other justices disagree with that and are pressing their point. And obviously, Bobby Jindal, Governor Jindal's position is the matter should be left to the justices of the Louisiana Supreme Court as opposed to the federal judiciary.
Yeah, well, it's a story that we're going to continue to follow.
We'll be covering it some more. Let's get to class action, shall we?
Yeah.
Val, it's an extremely complicated topic. There are commercials on TV every day about if you've been injured or affected by this product or the other. You've spent decades litigating class actions, fighting on behalf of people who are affected by class actions. Why don't you give us the big picture? Define for us, tell us, what are class actions? No
problem at all. Thank you very much, John. I appreciate the opportunity to be here with the both of you today. There are lots of misconceptions about class actions, and in its simplest form, a class action really is nothing other than a procedural device. It's a way that courts can handle cases involving large numbers of people who have the similar type claim. And that's always the first requirement of a class action. It's called numerosity. You have to have a sufficiently large number of folks who have all been adversely affected or claim to have been adversely affected, injured, or damaged, if you will, as a result of some common thing. So numerosity is always number one. Commonality, that is that the claims are common amongst all members of the class, is a second requirement. And then you're going to have certain individuals who are going to represent the interest of everyone that's in the class.
Well, let's break it up.
Sure.
Numerosity, a large number of people have to be affected. It can't be 5 people, 10 people. It's got to be a lot of people for this to be a, quote, class action.
Absolutely. And if you look at the cases here in Louisiana, the absolute minimum number is right around 40 or 50. There really is no upper limit, although that's certainly a consideration if you have hundreds of thousands of people. But the lower limit is right around 40 to 50. And in most class actions, you're talking about thousands or tens of thousands even.
In cases concerning Katrina and BP, we're talking about thousands there?
Tens of thousands, if not hundreds of thousands, obviously. Lots of folks had claims against their insurance companies. Lots of those cases were initially brought as class actions, later resolved on an individual basis, but the citizens class action, there are a number of class actions resulting from Katrina. The hospital, nursing home cases were all treated as class actions and pretty much resolved in that way as well.
Well, we got a lot to cover and only a little time. Commonality, that means everybody had very much the same or very similar types of injuries or claims.
Correct. Let me give you an example, just that. Let's say a particular, from Katrina, homeowners. If you were represented, or rather insured by Citizens, the insurer of last resort, all of the class members were insureds, right, of one particular insurance company. So there's commonality across the board in that they're all insureds of a particular defendant.
You all had
that
in common.
Yes, all had that in common.
Got it.
So then we go to typicality, if you will. All right, let's assume that you have 10,000 insureds of Citizens. Well, the court can't really deal with 10,000 folks coming into the courtroom on any one given day. There has to be representatives, folks who, 3 or 4 or 5, who are able to represent the interests of the other 9,995. Those 3 or 4 or 5 folks will be the class representatives. And likewise, the court requires that the claims of those class representatives be typical of the claims of everybody else in the class. So numerosity, commonality, typicality.
So the value of having class representatives, it avoids the necessity, at least as far as proving whether or not there's a case, of instead of doing 10,000 trials and having 10,000 juries convened and having all the witnesses come back 10,000 times, if that's humanly possible, the class representatives arrive, and if it gets to trial, you can establish your case that way.
Yes, they would be representing, again, the rest of the folks in the class for purposes of liability and potentially general causation. Individual damages are never handled on a class-wide basis.
Well, I got to tell you, when I hear class action lawsuits, immediately I think it's something that's going to involve a lot of people, a lot of lawyers, and it's going to take a long time. Am I right about that?
Well, generally, yes. Litigation does take a long time. The wheels of justice turn slowly. We've all heard that expression before, and they certainly do. By the same token, is it going to involve a lot of people? Yes, by definition, it has to. A lot of lawyers, generally speaking, yes, there's a lot of lawyers going to be involved because the court is going to appoint a certain group of lawyers, usually called the Plaintiff Steering Committee, because just as the court can't handle 10,000 plaintiffs coming in at one time, the court has a difficult time handling hundreds of lawyers coming in at one time. So the court will generally appoint 4, 5, 6, 10, 12 lawyers to sit in a committee to represent all of the interests of the plaintiffs and potential class members in the class.
Well, so the potential members, am I going to be contacted? Is this something that I'm going to seek out? If I go to an attorney, am I going to automatically know that there's a class action lawsuit concerning whatever issue I might have?
The legislature, in its wisdom, has handled that problem as well. There's absolutely notice requirements. And if we can determine who you are, either if we have your name, address, or from records or what have you, we can send you direct notice. Otherwise, the court will mandate that we publish in the local newspaper We used to have a daily newspaper. I guess now we have the Advocate. You publish in the local newspapers. Sometimes you publish in national publications, so as to get notice to folks that they do qualify as a member of the class.
Fascinating topic. There's so much more to talk about. We have to go to break now. If you'll stick around, we'll be joining you in another minute and talk some more about this very fascinating topic.